Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. During yesterday's historic oral argument before the United States Supreme Court, when the matter of Hunter versus United States was addressed, Justice Samuel Alito, as well as Mr. Hunter's counsel, cited to one of the many amicus briefs that were filed on behalf of Mr. Hunter. And that was a brief that was the work of the Cato Institute. The Cato Institute, in this landmark appellate waiver case, filed a legal brief joined by multiple other organizations. This brief essentially asserted, with respect to these appellate waivers, that any unconstitutional sentences that are imposed on a defendant who signs an appellate waiver should not be removed, should not be foreclosed from appellate review. We have provided a link to the Supreme Court's website where you can review all of the filings in Hunter versus United States. The filings from the parties themselves, which consists of a petition from Mr. Hunter, a response in opposition from the United States, and then a reply by Mr. Hunter, and all of the amicus briefs that were filed in the case that set forth various positions why the Supreme Court should look at grounds by which someone who signs away appellate rights would be able to still at some point have a higher court review the sentence. And those reasons vary from one brief which asserted that sometimes the prosecution hides exculpatory, that's favorable evidence to the defense, and it's not learned until after the appellate waiver is signed. Another focused on a study that showed that a majority of people surveyed agreed to plead guilty to something that they had not done out of fear of what could happen if they did not. Yet another opposed these negotiations as secret horse bargaining types of deals that go on behind closed doors that the public is not privy to until it's a done deal. And a party stands up in open court, such as Mr. Hunter did, such as Mr. Kohberger did in the very highly sealed case of Idaho versus Kohberger. And that's when the public may learn for the first time that a defendant has agreed to plead guilty rather than go to trial. And as part of that plea deal, the waiver of appellate rights is a condition that the government requires. What is up next? What can the public look forward to? There will be an opinion that will come out at some point between now and the end of June 2026, because that's the time when the Supreme Court wraps up business for the 2025-2026 calendar year, of which Hunter versus United States was one. Typically, one of the justices will be the author of that opinion. There will need to be a 5-4 at least majority decision by the Supreme Court to rule one way or the other, to rule in favor of Mr. Hunter, to rule in favor of the government, whether in part or in total. And that opinion will give the reasonings, will have citations to case law, possibly the Constitution, giving the court's reasoning for why they ruled the way they did. And it will serve as guidance for future matters on this issue of waiver of appellate rights. Please stay tuned to the Indie Zone for further developments. Until next time, this is Kathy. Thank you for joining us here today.